We are now just hours away from learning the verdicts from the sexual assault trial of 5 former World Junior hockey players. Justice Maria Garcia will deliver the decision in Superior Court in London today. Foote, Dillon Dubé, Alex Formenton, Carter Hart, and Michael McLeod have all pleaded not guilty to sexual assault for an incident that allegedly occurred in June 2018. McLeod has also pleaded not guilty to a separate count of being a party to the offense. Experts say the judge's decision, it could set a new precedent in this country for what consent looks like in the eyes of the law. For more on what we can expect, we're joined by criminal defense lawyer Kim Schofield. Good morning to you.
Yes, good morning, Lindsay.
So this 8-week trial saw 2 different juries being dismissed, a mistrial declared. What is your sense of where the case stands heading into today?
So keep in mind it's now a judge-alone trial. So there's certainly some benefits to that beyond being a speedier process, perhaps. One of the benefits is, of course, we get her decision today. And I say benefits because in a jury case, we don't know the reasons. So the reason why everybody is watching this is, what is Her Honor going to say about consent? Is it the Crown started this whole case with their intro that this case will challenge notions of consent. Now, what Her Honor has to decide is what constitutes consent, what reasonable steps must be taken in order for an accused to obtain consent. So it's really about that reasonable steps in this case.
Because, and I want to dig into this a little bit deeper, because you mentioned, when you have a jury, you only get the verdict, right? Guilty, not guilty. We are going to hear the reasons why the judge arrived at the verdict today. So let's talk a little bit more about the importance of sort of the backstory of how she is going to get to that decision and why that really matters for future cases.
So keep in mind, there's a defense called mistaken belief in consent. So the Crown must prove that an accused committed an assault for a sexual purpose, and that's what a sexual assault is. And one of the defenses to that is that, in fact, the behavior happened, but the complainant consented to that behavior. Now, consent might actually be there, or an accused may perceive there to be consent. So this is a case, first of all, let's just back up a little bit. The defense does not say that this is a mistaken belief in consent. The defense says the complainant is not being truthful, that she actually encouraged sexual behavior, she asked for sexual behavior, and she actually did consent. Now, the complainant says that she didn't say no. In fact, she said yes. But it was in circumstances that it was not reasonable for the accused to believe that she did in fact mean yes. So in other words, the consent was obtained through threat or through an oppressive situation. So there weren't direct threats, she said, but the whole situation was threatening. And as a result, the consent that she did give was not a valid consent. And that's what Her Honor has to decide. The Crown says, look, in that situation, in order for there actually to be consent, there has to be an inquiry made by each individual accused.
What will happen today in terms of procedure? Will the judge walk through each individual separately? How do you expect this is going to work?
So keep in mind, this is not an all or nothing. So the facts are such that the consent was obtained, according to the defense, by each individual separately, either directly, and we heard post facto or after the fact video recordings, which the judge will also comment upon, the use that she can make of those. So the judge will actually take the court and all the accused through each individual accused and apply the law to each individual accused, because the verdicts may be different for each of them. Her Honor must assess the credibility and reliability also of the complainant. So if the defense raises a reasonable doubt about whether she actually did consent, so in other words, whether she's actually telling the truth, then they could be just acquitted on the basis of the fact that the judge does not believe beyond a reasonable doubt that, in fact, she's telling the truth about that. Or, because it happened so long ago, because alcohol was involved, because there's prior inconsistent statements, the judge may just have a reasonable doubt about her reliability on the issue of consent. So there are many, many hurdles for the Crown to get over before a guilty verdict is actually rendered.
Lastly, I just want to ask you, if one of these individuals is found guilty, what could they be facing?
Well, the maximum jail term is one of 10 years. Now, they won't get 10 years, but they would most likely get some form of custody. That seems to be what the case law demands these days. So in the lower reformatory, so 2 years or a little bit more than 2 years. That seems to be what the law demands.
All right, we'll be watching. Kim Schofield, we appreciate your insight on this. Thank you.
You're very welcome. Have a good day.
You too. We'll be right back.
If you like that video, make sure to subscribe to the Your Morning YouTube feed, where you can find all kinds of new content posted every weekday morning.